And he said it was okay. So let's turn to this panel, and I'm going to introduce our speaker by telling you that my first time in this room, the McNally Auditorium, was 8 years ago, I think. And I came to hear Marty Flaherty, who is moderating this panel, debate John Yoo. It was my first introduction to John Yoo. It was also my first introduction to Marty Flaherty, for that matter. And as you know, the torture memos, John Yoo, and that conversation has been at the forefront and the center of everything we thought about at this center and at the NYU Center prior to that. Marty is the person who I first talked to about coming to Fordham Law School. He is the Leitner Family Professor of Law, co-founding director of the Leitner Center for International Law and Justice here at Fordham Law School. He is one of our students' favorites, which is very good for me because he gets them ready to take this course in terrorism, national security, and civil liberties that I teach. He has a particular interest in Asia and China. He has written widely about presidential powers, about international human rights law. He covers that area where domestic and international law intersect, and it's so much an issue when it comes to national security. If you want to read something by him, I would recommend anything he'd written, but perhaps you should look at his article for the Yale Law Journal in 2005 called The Most Dangerous Branch, which talks about the powers of the executive that Hina and others refer to in our former panel. So, without saying anything else, Marty.
Great. Well, I'll get things started sitting here. Thanks very much, Karen. I think the positions that John, you and I took in that debate may have had something to do with him going into government, and me not. In any case, I'd like to thank Karen for bringing the center essentially to Fordham, and also for organizing this conference along with Susan. I think this is exactly the kind of dialogue we need both at the law school and then more generally. So I just want to give that shout out. Now, this panel is going to move from ethics and policy to the law, although as you saw from last panel, it's hard to keep the two distinct. And in fact, comporting with the law has something to do with ethics and policy as well. And I was thinking about Steve Cole's remarks concerning the moment we're in. He talked about perestroika. I was thinking more grandiosely perhaps about an American Spring with regard to counterterrorism policy. And then I thought, well, it's still pretty cold outside, so at least perhaps we can talk about an American thaw. And you know, the thaw goes to the point that we have individuals both on the left and right, people ranging from Senator Ron Paul to John Podesta to John Bellinger, Jack Goldsmith to David Coles and Hina Shamsi's of the world, agreeing to engage anew on where our counterterrorism policy should go, and agreeing beyond that on many key points, especially the transparency point, with regard to legal standards concerning targeted killing. As was said in the last panel, almost everybody out not in government agrees that there should be more transparency. And indeed, there are many in the government who are pushing for more transparency, apparently. This panel will move that discussion to the types of things that we would hope most of us of the government would be more transparent about, which are legal standards concerning targeted killing, and then legal standards more generally concerning the authorization of counterterrorism policy. So with regard to legal standards concerning targeted killings and drones in particular, that logically tends to divide into two large categories. One, which we haven't heard that much about yet today, which is the international standards, both the use ad bellum standards concerning international law, which is when is it appropriate to use armed force beyond your borders, and then the use in bellum standards, which is when are the types of force used appropriate, necessary, not indiscriminate. What we've heard about, and I hope to hear about more, are the domestic constraints, if any, on presidential discretion to engage in targeted killing. And this is where the new debate concerning and apparently new plausibility about drone courts comes in. We could leave it there, but I suspect the debate and discussion will range further because, as you also heard this morning, there's a quite lively debate involving many of the people here on this panel on a blog you should all know about, which is called Lawfare, concerning whether we should have a new version, an updated version of the AUMF, or whether that would make things worse than they are today. And I suspect that some of our panelists will engage in that discussion as well. So without anything more from me, I'm going to follow Steve Cole's example and not give extensive introductions and just turn things over to our panelists for brief remarks. And so let me first turn things over to Steve Vladeck, who is the professor and associate dean for scholarship at American University, Washington School of Law.
Great. Thank you, Marty, very much for the introduction, for moderating this panel. Thanks to Karen, as always, for everything, and to Susan and Steve for their help in putting this conference on. So I have the, I think, unenviable task of trying to tie together Jay Johnson's speech this morning, the last panel, and what we're supposed to cover in this panel. And so I thought what I might try to do, and do that all in 5 minutes, is to use the shell of one of my favorite law review articles from when I was actually, learning about this stuff for the first time. So in 1988, in the Columbia Law Review, John Cardilli published an article titled, "Suppose Congress Wanted a War Powers Act That Worked." Needless to say, John was a little bit skeptical that Congress had in fact done that. So I'm going to sort of call my remarks, suppose Congress wanted a drone court that worked. And indeed, I have a very simple 7-step program that I can sell to you on how this could work contra the suggestions this morning of the former DOD General Counsel. So first, step 1, if you wanted a drone court that worked, that is to say, if you wanted a meaningful judicial remedy to put the drone program on more firm legal footing, it seems to me that the first priority is that review be after the fact, at least in addition to, if not entirely exclusive of, ex-ante review. So Jay Johnson's remarks this morning were primarily about the shortcomings that you would see from both a policy and legal perspective with review of a drone strike before it happens. I think those concerns largely evaporate in the context of after-the-fact review. Indeed, if we think about it, courts constantly are asked after the fact whether something the government did was justified by the imminent threat, whether a law enforcement officer was justified in using lethal force. These are questions that are much easier to resolve afterwards, and indeed that we do it all the time. So after the fact review, step 1. I think step 2, it should be a cause of action for damages as opposed to a new court. So in other words, step 2 of my 7-step proposal for a drone court is no court. Right? You don't need a new court, we have courts. What you need is a cause of action. And if you think it might be strange for Congress to pass a cause of action as opposed to a new court system for super secret programs, consider that in Section 110 of the Foreign Intelligence Surveillance Act of FISA, Congress, which in the rest of FISA had created a brand new super secret court to hear foreign intelligence surveillance search warrant applications, created a freestanding damages cause of action for those who were aggrieved by violations of FISA, and then sent them into the regular courts. Right? So step 2, damages cause of action modeled on FISA. Step 3, if in fact the drone strikes are being carried out under color of law, then make the United States the defendant. Rather than have these proceed as officer suits, waive the federal government's sovereign immunity, substitute them as the defendant, and that way there can't be any of this, he was just following orders nonsense. Right? This is the model that the Congress followed in 1988 in the Westfall Act, which provides that in any tort suit against the federal government arising out of the scope of a federal officer's employment, the U.S. is substituted as the defendant. So step 3, U.S. as defendant. Step 4, override the state secrets privilege. And a model for this is the State Secrets Protection Act that has been introduced in 3 of the last 4 Congresses. So The biggest problem, obviously, with suits challenging the drone program will be the state secrets concerns that arise from them. But I am one of those who believes that the state secrets privilege is entirely a common law and not a constitutionally compelled privilege, and that Congress may therefore override it. And so therefore, step 4, Congress should override it. Now, step 5, before my friend down the end of the table starts throwing things at me, that's not to say that there shouldn't be provisions for secrecy. To the contrary, I think there are 2 models Congress could borrow from to allow for these proceedings to simultaneously unfold on the merits while protecting the government's interest in keeping certain information secret. So the first is to borrow from the Guantanamo habeas litigation the idea of security-cleared counsel who are entitled to represent the plaintiffs in such suits. That is to say, the counsel will have access to the evidence, if not the parties themselves. And that's actually worked fairly well, I think with some caveats in the Guantanamo context. There are reasons to quibble about it, and we can quibble all we want, but at least it's been better than nothing. But also, a statute I suspect very few have ever heard of, called the Alien Terrorist Removal Act, which is part of the 1996 immigration laws, has actually a really thoughtful, really sophisticated provision for dealing with secret evidence in similar contexts. So if you really want to go check out a fun statute that Congress actually put some thought into, go look at 8 U.S.C. section 1534E. Trust me. Okay, so that's step 5. Model secrecy on Gitmo and on the Alien Terrorist Removal Court process. Step 6, get rid of immunity. If the federal government's going to be the defendant and we don't need official immunity, there's no reason why you have to worry about whether the law was clearly established or not. Just resolve, was the strike legal or not? And that brings me to step 7, which of course is the hardest step, which is what the law should actually be. And I think because it will be so hard for folks to agree on any standard set of rules to govern such uses of force, it seems to me Congress could punt. And as it has done in other statutes, Congress could simply say that a cause of action lies for any use of military force under color of federal law, so to encompass uses of force by individuals who are not in the military, in violation of federal law, in violation of the Constitution, laws, and treaties of the United States, and then leave it up to the courts to sort out just what that means. There are lots of problems with that proposal, but I think very few of them are constitutional, and I think only a couple more are legal. The real central problem with that proposal is that it has just as much of a chance of actually happening as the very real war powers resolution for which John Hart Neely argued in his 1988 Columbia Law Review article, in lieu of the one we already had. Instead of talking about how Congress might meaningfully do this, our attention has increasingly shifted to whether Congress should instead revisit the AUMF, as Marty said, and sort of create a new framework for extra AUMF threats. And so since I'm done with my 7-step program, I'm going to cede the floor to Jen, so she can pick it up there.
Great. Thanks, Steve. So next we'll hear from Jennifer Daskal, who is former counsel to the Assistant Attorney General for National Security and currently fellow at the Center on Law and National Security at Georgetown Law Center, where she's also an adjunct professor of law.
Okay, thank you, and thank you again to Karen for putting together this wonderful event, including me, and for the Center for everybody's work in making this happen. I think it's a really important issues, and it's incredibly timely and important that we're all discussing them today. I am hoping that during the discussion that I will have some time to get back and talk about the question of a drone court or other similar ex-ante review mechanisms that could be implemented that I think do have some benefits that have been understated by some of the remarks by Mr. Johnson this morning and by my friend and colleague on this panel, Steve. But I want to move, as Steve suggested, to talk about what I think are the 3 most critical questions that are facing us right now, which is, when does the conflict end? How do we define that? We've heard a lot about that this morning. Secondly, once this conflict ends, how do we address new threats? And even before this conflict ends, how do we address threats that are not covered by the AUMF? And then third, how expansive or how limited is the related self-defense authority that's inherent under Article 2? We've already heard a lot about the end of the conflict, so I'm not going to spend any time really talking about that, and instead move to the question of what is next. You've heard from a variety of speakers this morning that there is an active debate going on the lockdown law involving 3 of the panelists up here, including Stephen and Bobby, as well as others, about what happens next. And so I want to just clarify what I think are the key points of agreement and the key points of disagreement. So I think when you get to the bottom of what's up this debate, I think there is a general agreement, at least amongst us on this panel, that the AUMF cannot and should not be shoehorned to cover more and more associates of associates of associates of Al-Qaeda. And we also agree that there are some threats that exist that are not covered by the AUMF. Some of these threats existed before September 11th, some existed 3 days after September 11th when Congress did pass the AUMF, and some new threats exist now. And so my argument, I think Steve shares this view, is that the primary mode of operation for dealing with these new, emerging, and sometimes not just new emerging threats ought to be law enforcement and intelligence tools, which have grown in strength and substance over the last decade and have proven to be extremely successful, not only in dealing with homegrown terrorist threats, but also threats of international terrorists posed by specific individuals overseas. Both criminal justice tools used by the United States directly and criminal justice and intelligence tools used in collaboration and cooperation with our international partners. Now that said, we don't think that this is the only way to deal with new threats. That if and when there is a situation where we face the type of threat that the United States faced just before and just after September 11th, Congress can and probably should pass a new AUMF to deal with that type of threat. And in the interim, before Congress can act, the President has, as he has always had, his Article 2 self-defense authorities to deal with imminent, significant, and active threats to the homeland. Now, in the debates that some of you may have seen on lawfare, there is an argument that there ought to be a new AUMF that essentially delegates to the President the authority of the executive branch, the authority to list additional groups that could be covered by this AUMF without a congressional specific determination that each specific group ought to be covered. And it's unclear to me, and I think to Steve as well, as to why this is needed, given the possibility of going to Congress if and when a new threat emerges that justifies the use of the AUMF. And so their concern is that this would essentially lead to a situation where you are creating a new authorization to use force at the very time that the war is winding down. It's unclear why this is needed. I think you'll hear from Bobby that some of the reasons that they're arguing for this are a desire to include certain types of accountability and transparency mechanisms into the authorization to use military force. With this, I am fully on board, and my response is, let's include them in either the existing AUMF, or let's specify that if and when the President exercises the self-defense authority, let's be public about who he's attacking, and let's require that as a matter of law. But that, in my opinion, does not justify the implementation and the creation of a new AUMF. And finally, I'd just like to end with a quote that I'm sure you are all familiar with, that was said to Kevin Costner. If you build it, it will come. If you authorize it, it will be used. Thanks.
Thank you, Jennifer. So next, we will hear from James Ross, who is the Legal and Policy Director of the Federal Law.
Thank you very much. Good morning, still. Good afternoon. First of all, I'd like to just have a word about the title, The Laws Governing Targeted Killing and Non-Traditional Warfare. 150 years ago next month, Abraham Lincoln supported what was the first modern codification of the laws of war. They were drafted by a professor up the street at a university, I can't recall the name of it. This was an important document. And of course, it concerned an armed conflict between a state, the United States, and an enemy armed force that actually was not a recognized state. And in fact, there were provisions of this code, the Lieber Code, that dealt with guerrillas and other irregular forces. So the notion that we're dealing with something new and unusual is quite wrong, and I agree with Gabor from the earlier panel. that we do have a body of international law out there that can address these situations. It's clear from the statement of Mr. Johnson and the U.S. government generally that they view their actions as part of an armed conflict, wherever the attacks may take place. And from the perspective of military officers, that's understandable. They're trained in the laws of war, and their view is the law goes wherever the combatant goes. But that approach really ignores another body of law out there, and that's international human rights law. And in looking at these issues, one needs to look at where international humanitarian law, the laws of war apply, but you can't ignore international human rights law. Now, in my remarks, I was going to discuss a bit the differences of IHL and human rights law, notions of imminence, and the like. The previous panel was talking about policy. When you put lawyers on a panel, we'll end up talking about law. So, as a human rights activist, instead of talking about the law so much, or I'm not going to go into the details later, I actually want to talk about the facts, because the facts do help us understand what's taking place out there. Looking at drone strikes has been particularly difficult, as Mr. Shah alluded to, in Pakistan, because many of these strikes take place in places that are really inaccessible. Human Rights Watch has done a lot of work on sectarian violence in Pakistan, including in really dangerous places. We were still able to get the information. But getting to northern Pakistan, Waziristan, and the like has proven really difficult. At the risk of annoying a colleague of mine who's in the room who actually did the research, I'd like to relate just one incident that she was able to investigate, that gives you some idea of what's going on and raise some recommendations in terms of how the U.S. needs to address them in accordance with international law. On September 2nd last year, in the town Al-Baida, it's about 100 kilometers from Sana'a in Yemen, in central Yemen. There were drones flying around, and a vehicle was then struck by a missile or a bomb, it's unclear. And 12 people were killed. And it turns out they were all civilians, 3 children. And in fact, the Yemeni government admitted that they were all children. My colleague, Vladeck, who's here, who's written about this in Foreign Policy, and I urge you to read her full account, wrote about this and about this incident. It was clear that the U.S. government was involved, because even though it may have been aircraft or drones, there were drones involved, which Yemen doesn't have. Yemen apologized to the families and even offered them some redress. But the U.S. government has not formally admitted any role in this attack, though it's very clear that the U.S. was involved in this attack that killed 12 civilians last year. We don't know how many other incidences there are like this. So what's needed? In short, international humanitarian law, and here I'm just assuming that international humanitarian law applies, and that's a debate one can have in Yemen, whether it applies, whether the U.S. is fighting a war alongside Yemen, though the United States does not say it's doing that. And the question is, what does international humanitarian law require? First of all, when there are credible reports of civilian casualties, there is an obligation under international humanitarian law to investigate that. And if there are apparent violations, there needs to be apparent violations of the laws of war, possible war crimes, there needs to be prosecutions. This is possible when the U.S. military is involved, but we know the drone campaign has been run by the CIA. The CIA neither admits participation nor denies participation. So how can you have any meaningful accountability when the CIA is effectively running the program? So an important element is moving that to the military, where there are issues of accountability. It is Human Rights Watch has learned in places like Afghanistan, we can address them on these issues and actually make progress. So there needs to be investigations. There's already been a call for the U.S. to release its memos, its legal memos in terms of how it operates. But then I'd make one final suggestion, and this relates to drones themselves. A drone, whether surveillance or an armed drone, has a camera. One of the values of it as a military weapon is it is filming what it is attacking. And even the missiles that are fired by drones have cameras on them. So there's a whole body there of evidence that should be able to prove whether an attack was lawful or not. And the U.S. and others who intend to use drones should use them as well.
Great, thank you very much. And finally, we'll hear from Robert Chesney, who is Charles I. Francis Professor of Law at the University of Texas.
Thanks, Marty, and thanks to Karen, Susan, and Steve for including me in this wonderful event. It's a pleasure to be here. So Jen closed with the quote, "If you authorize it, it will be used," which is a good way to capture, I think, the concern that's motivating her and Steve in their response in this debate, which I'm going to describe in more detail in a moment. But I want to suggest to you that it is being used anyways, and that part of what drove my co-authors and I to write the paper that I'm about to describe to you is the sense that the status quo, or the option, the choice that's limited in front of us, isn't one in which the only force being used, the only lethal force being used, is the very rare and episodic use of military force to preempt an attack that was about to come off that strict moment, but rather something that looked just like what we're currently doing, and that we can do better than this. So let me explain in more detail what this is all about, because there have been references all morning to this debate that's going on in the blog and so forth. There's a paper that I co-authored with Jack Goldsmith, Matt Waxman, and Ben Wittes. It was distributed by the Hoover Institution. It's called the Statutory Framework for Next Generation Terrorist Threats. It's a concept paper that was meant to be short and provocative and to stir debate, and it's done that, which I'm very happy about. Let me give you a quick overview of it so you have a sense of what it is we actually had to say there. The first part of the paper begins by making the claim that there is indeed a growing problem of so-called extra AUMF threats. That is, that the range, what Mr. Johnson earlier described as the threat stream, is coming to be dominated more and more by groups that are not properly described as core Al-Qaeda or the Afghan Taliban. As we all know, the core Al-Qaeda network is not what it once was. It's not gone. The war's not in, the conflict with it is not ending tomorrow. But we're closer to that point than perhaps we've ever been in the past since 9/11. At the same time, the Afghan Taliban are growing increasingly marginal to U.S. security interests as we draw down, and that will perhaps continue to be the case. But at the same time, as Mr. Cole mentioned earlier, we all understand that Al-Qaeda has greatly fragmented in complex ways. Some of it involves regional cells that have broken off and developed their own independent stature. Some of it involves entirely indigenous regional organizations that have come to be co-branded to varying degrees, to have varying degrees of connections with Al-Qaeda, not all of which entails becoming subject to the group's direction and control. It creates an issue about the organizational boundaries of Al-Qaeda. And as the Washington Post recently confirmed in a story that was chock full of interesting leaks from senior officials from within the White House, this has become a matter of very pressing concern within the White House, DOD, the intelligence community, and state as they grapple with the question of exactly who is the enemy at this point and how does that match up with the AUMF. One way this has been handled, and it's not a brand new problem, the way it's been handled up till now has been to talk about associated forces. Mr. Johnson referred to this, and it is true that in the habeas litigation, there's been some endorsement of the associated forces concept, and it's true that Congress in the National Defense Authorization Act for fiscal 12 also, at a high level of abstraction, endorsed the notion of associated forces, but the concept itself remains undefined, as the earlier panel repeatedly noted. I think both Henna and Gabor noted that we don't actually know, and David noted, we don't know really what associated forces mean. The most you ever hear is, well, it's analogous to determining who's a co-belligerent in a state versus state international armed conflict. That's not actually that helpful. We don't understand how the concepts apply, nor do we know how it's cashed out in particular cases. though everyone seems to understand and know that at least AQAP is thought to be under that umbrella. I guess one question that arises then is, do you still feel that way about AQAP if and when core al-Qaeda is gone? Does it remain legitimate? Does the AUMF hang around just for the associated forces? And what to make of the Washington Post story saying that the current debate within the administration is whether the AUMF also extends to associates of associates? Do the associates, does AQIM count? And if so, do other smaller groups in the area that are connected to AQIM, do they count by extension? Does the Al-Nusra Front in Syria count by extension from AQI? Does AQI itself count? These are the sorts of issues that are in play here. So what our concern is that the AUMF, which is the current statutory foundation, is being used with an underlying daisy chain of associational reasoning that begins to seem ever more implausible day by day as we move away from 2001 and becomes more so all the time. We try to be very clear, actually, quote here, we do not claim that all terrorism-related threats can or should be dealt with militarily. And we say that law enforcement and intelligence tools can have tremendous effects. So I agree with my colleagues that, as Ben said, a point of agreement, I think you said a point of agreement is that these are important and powerful tools. I think all the authors in this paper, certainly myself, are all on record saying that it's an outrage that Congress has made it so hard for the president to be able to use the criminal law enforcement tools that should be available to him. I'm a big proponent of doing so. We take the position that there are some cases, some circumstances where extra AUMF threats, perhaps most likely by dint of difficulties of capture, aren't amenable to a law enforcement solution. And I think the existence of the internal administration debate, as revealed in the Washington Post article to which I'm referring, reinforces that particular perspective. Assuming that to be the case, but not actually arguing that it is currently the case, that it must be done now, we then say that sooner or later we're going to face the question, should you just stay with the status quo, which is to say, keep stretching through the daisy chain reasoning, the AUMF, and then fall back on Article 2 as needed, when you think you have to use a non-law enforcement option? Or should Congress get involved or prepare to get involved with some sort of fresh statutory authorization? Well, let me just say, I've already suggested why I think the AUMF standing alone, as it currently is not adequate and good comfort for us. I do want to say something about the notion that's been aired a few times today that look, it'll be enough if we have Article 2's national self-defense authorities to fall back on. They'll be real narrow. They'll be different in kind, presumably, from what currently is taking place. I don't think we can think that at all. I think that all the evidence that's before us now is that the understanding of imminence, at least as construed by this administration, and surely as would be construed by a Republican administration, the understanding of imminence is a very broad, non-temporally oriented one. I don't think the Article 2 authorities that would then be used would look any different than what's currently happening. From that perspective, my co-authors and I argue that Congress should both create some sort of mechanism for clarifying exactly in a public way, who it is we claim are the enemies against whom we can use force. And in doing so, to include things like sunsets, increased post oversight provisions and so forth. I can see I'm past my time, but I just want to push back against the notion that what we've written here is a call for an expansion of the status quo, to go new places and do different things and use power in ways that are more expansive. From our perspective, these things are going to be done. The question is, how transparent and public is it going to be? How much role is Congress going to have in having oversight over it? How much are you and I going to know about who the enemies are? So I'll stop there.
Great. Thank you, Bobby. All right, well, I'll stand up here too, so it's good to see everyone. So it seems to me there are three, first of all, thanks to all the panelists for really great presentations. It seems to me there are three issue areas, three bundles of questions to ask. And before we join the debate about the AUMF, or what I'm characterizing already as AUMF 2.0, first I'd like to ask a couple of issues about the drone court. And the two questions I have, the first one would be for Steve, would be, why just ex post? Why not ex ante? Is ex post going to be enough? And then beyond that, and this is an issue that Jay Johnson talked about this morning, citizenship or not. And here I may or may not be, a heretic, but I don't read citizenship as a limitation in the Fifth Amendment. It's odd to me why citizenship, other than in political discourse, has seemed to be an accepted marker. Why is citizenship versus non-citizenship a relevant legal category when we're talking about constitutional constraints on what the president can do? So,
so on the first question, I think I am not as averse to some modest ex ante review if it's packaged with ex post review. I think the problem is that those who have put out proposals for drone courts have framed ex ante review as being exclusive of ex post review, and I think that that's not a good idea, and I think there's 22 all things ex post review could do. And in any event, I think it's important to recall that separate from the policy arguments, there's one very important legal constraint on ex ante review, which I think is actually a bigger deal than the Article 2 issues Jay Johnson mentioned this morning, which is the Article 3 requirement that the federal courts can only hear cases in controversies. I'm not sure what the case is if the government were to walk into a federal district judge offices and say, we want a warrant that says we can go and use force against this person. Right? In the criminal context, the whole justification for the search warrant regime is that it's preliminary, it's necessarily antecedent to the criminal prosecution that follows, it's therefore part of the case and controversy that results. And indeed, you can collaterally attack the warrant, you can litigate it after the fact. That's not going to be true in this context. So, I think the biggest obstacle to ex ante review, if it's bundled with ex post review, is actually a constitutional constraint. And actually, if you can find a way to get around that, then my policy objectives, I think, are largely ameliorated with bookended ex ante and ex post. Marty, on the larger question of citizenship, I have to relate this very weird experience I had. So speaking of John Yoo, John Yoo and Andy McCarthy and I were on a Federal Society Teleforum conference 2 weeks ago, where John Yoo's argument was actually yours. By which I mean, John said the reason why we can't have a due process for Anwar al-Awlaki is because we have due process for everybody. Right, that here was John Yoo arguing that the due process clause applies to everyone, subject to U.S. authority anywhere in the world. I'm trying to my 7-step plan operates in the world of what's currently the law, so sort of a Dworkinian, where are we now? And the reality is, for better or for worse, the Supreme Court has drawn these distinctions and has suggested that the Constitution does not protect non-citizens outside the United States to the same degree that it protects citizens. It has hinted that perhaps the due process clause does not apply to non-citizens with no substantial voluntary connection to the United States. And so I actually think if you are serious about a drone court or a drone remedy, there's no reason to differentiate in entitlement to bring the claim based upon citizenship. What's going to happen is the merits are going to catch up very differently based upon whether the victim, the target, is a citizen or not.
I want to chime in real quick on the Article 3 concerns. So this is rehearsing a discussion Steve and I had in front of the House Judiciary Committee a week or so ago.
You guys are a better audience.
This is much better. No disrespect intended. So my position is, I'm actually, I guess I'm to the left of you here because I actually think that, literally and figuratively, because I think that there is something to the ex ante court idea, and of course it's something that Jen has written about as well. I want to give acknowledgement there. On the Article 3 concern, as Steve knows, my view is that it's not so clear this is a deal breaker for the ex ante idea. FISA, of course, is an example in which, in the first instance, it's certainly not adversarial, and it looks exactly like this. It's just a different question being asked, not that different outcome. In the FISA context, of course, later on there is the possibility that in the off chance that the FISA warrant is later used in a criminal prosecution of the person, then they get to know about it and get to challenge it. But that challenge is always ex parte. The challenge isn't worked out the way that an ordinary warrant challenge would be, a suppression motion would be in a criminal case. That's not dispositive. It's just to say that we've gone part of the way towards gutting the case of controversy requirement here, and we've gone a little bit further with the FISA Amendments Act and the certification procedure, which may or may not turn out to be the case that gives the court an occasion to say, no, judges can't do this, in which case then the ex ante idea does go away. Or they may say, yeah, this is tolerated here, so maybe we can extend it a little bit further.
So just to put some meat on that, I actually think Bobby is right, but in a sort of strange kind of way, I want to disagree. And so let me sort of elaborate, right? I think Bobby is exactly right that to say that FISA is constitutional by analogy to the ordinary criminal process model, is a fiction, right? That in virtually no case is evidence that is obtained through a FISA warrant actually admitted at trial. Even though step 3 of my brilliant plan was to model on the FISA damages cause of action, there has been, I think, exactly 0 successful 1810 damages actions. So it is true in the FISA context that never actually happens. The problem is that the 3 cases that have upheld FISA against an Article 3 challenge nevertheless all rely on the fiction. That it is at least possible that because this is part of a criminal proceeding, it still satisfies the Article 3 case and controversy requirement. And I don't know how you could stretch that fiction to cover drug charges. Indeed, I don't think you can stretch that fiction even to cover the non-warrant regime that Congress created in the FISA Amendments Act.
I have Jen want to get in on this.
I just want to suggest one, because I agree with both Steve and Bobby, actually. And Steve started his comments by saying people who propose an ex-ante review system tend to not also propose an ex-post review system. And that's not my case. In my case, I propose both. I think they're both important. They both serve important functions. In many ways, an ex-post review system serves a more robust and a more important function, but I think they're both critical for different reasons. I think that you can get around this race to the same way that in FISA, there's this fiction that there will be an aggrieved party who can actually challenge the order. You could, especially if you're creating an after-the-fact damages regime, you could statutorily create such a regime that would satisfy this race within legal fiction. I believe Steve or maybe both of you that eloquently described it. I also want to suggest that I think while we're focused on this Article 3 issue, there's another way to structure this, which is to have Congress mandate some sort of internal Article 2 review board, incorporating some of the ideas that were discussed by David Cole and by Jay Dawson earlier, in which you have some sort of advocate playing the role of the potential target whose job it is to amass the best arguments in support of his case. And whether it's an Article 2 review system or an Article 3 review system, I think it serves the purpose of providing an added layer of check and accountability before a state engages in this extraordinary power to deliberately kill another individual. I am well aware of the real and I think significant concerns that once you create such a system, you institutionalize it and legitimize it. At the same time, this is a power that the United States and presumably other countries are engaging in and probably will continue to engage in, and having additional checks and additional accountability measures, I think, serves, on balance, a more important function than not having such a system.
An ex-ante court raises interesting U.S. constitutional law questions. From the perspective of the rest of the world, a court that, with all the problems that have been raised already, and it looks like a FISA court, which traditionally has rubber-stamped U.S. government actions, will do nothing to address attacks by the U.S. that violate international law, regardless of whether it's viewed as acceptable within a U.S. legal debate. And this is not a useful road to be pursuing because of that.
So let's move to AUMF 2.0 or not. And I guess two questions that arise here are, and I'll direct this initially at Bobby and then invite further discussion. One is, what exactly is the level of threat that would be necessary to trigger the military model as opposed to the criminal justice model? How strongly must the threat stream be flowing? And then secondly, could you go into a little more what the potential benefits of a second AUMF would be with regard to oversight and related matters? Because the fear would be this could be just another congressional rubber stamp, not unlike the initial AUMF. So,
great questions. So in the paper, we to some extent try to remain agnostic about what the standard would be. Well, let me back up. People I will not assume have read the paper. We know that there are several possible solutions here. One would be the simplest solution if one thinks that there are currently significant threats of this kind, and I'll get to what the threshold is. If you think they're already there, just having a new AUMF that names them. So let's say for the sake of argument, you think that the one entity in the world that fits this bill that arguably isn't core Al-Qaeda, but against whom we should be using military forces, AQAP. You could have an AUMF that says as much, just says so. We suggest that it might be worth looking at a different option in which something akin to a listing regime, not unlike is used by the State Department to designate foreign terrorist organizations, where Congress sets a standard, and this is where the question comes in, what is the standard? Congress can set the standard, the executive branch can then make a public designation of who it is they at this moment have decided has made that threshold so that it becomes clear this is a replacement for what is currently happening, which is internally the same sorts of discussions are going on under the guise of, is this an associated force? But you and I don't have any idea about it except when there's stuff that leaks out. So we don't say that the right standard should clearly be framed as X. But personally, my own view is that, and this, I can't necessarily speak for my co-authors here, I think what you need to have is a demonstrated, not just a possible, but a demonstrated capacity and desire to kill Americans, to have attacked an embassy, to have tried to actually carry out an attack. Or at least a strict temporal exigence as a measure of that group's not just being a foreign policy problem for us, but an actual threat to American lives. Something along those lines. And of course, the devil is in the details of how you frame this sort of thing. This is just an off-the-cuff kind of response. The benefits of this sort of solution we're talking about here and doing more than the status quo, first and foremost, the theme of the morning seems to be transparency. We ought to know what the groups are against whom we're using force. And although very often members of the media who are not as savvy about this stuff as Steve or as Danny, there are people who know this stuff really well, but there's a lot of people who don't, and everything's just Al-Qaeda. Right? They're all just Al-Qaeda. And an Al-Qaeda group has emerged in Syria, an Al-Qaeda group has emerged in Sinai, an Al-Qaeda group has emerged in Mali. Well, it's, of course, not that simple at all. And we think that the fundamental virtue of the approach we're advocating is to force public debate, dialogue, and transparency on who these entities are. We do suggest that if you're going to take the sort of measure we're advocating, that it should be hedged about with sunsets, with greater clarity as to which entities in Congress are going to have oversight over which types of actions. I think on the last panel, maybe Anna referenced the idea that if you move the use of lethal force in part out of the CIA's hands and entirely into JSOC's, Joint Special Operations Command's responsibility, it's not at all obvious that the House and Senate Armed Services Committee exercises sort of granular oversight that the Senate and House Permanent Select Committees on Intelligence do for CIA activity. These are the sorts of things that could be addressed.
Responses? About this, I'll jump in on the sort of, I mean, what this really boils down to is assume a scenario where a group, whether it's Al-Qaeda in the Arabian Peninsula or Al-Qaeda in the Islamic Maghreb or any other such group, the question is at the point where they cross some threshold, and I actually want to say I think the devil actually is in the detail on the threshold. Because if the standard is simply intent and capacity to kill Americans, I think that sweeps pretty darn broadly. But I think it also has to be on U.S. soil, or I wouldn't say that. I mean, East African embassy bombings, for example, in 1998. So one small-scale terrorist attack against a U.S. outpost anywhere in the world authorized
small-scale.
And you said intent or capability to kill Americans. So killing one American in a terrorist attack on a foreign military base thereby gives Congress the power to authorize these military force against the group of which that person's a member.
So the entity that carried out the Benghazi attack. So Benghazi is a good example of the sort of thing I'm talking about. Like that level of demonstrated, let's say for the sake of argument, we knew exactly which group did that, and it was not an Al-Qaeda group, but so maybe a fellow traveler, but not an Al-Qaeda group. That level of activity, I think, would cross the threshold.
But I guess that's quite, I think, a revelation, because I think if that level of activity crosses the threshold, then what you guys are actually proposing is in fact a war against any terrorist group anywhere in the world that ever harms any Americans. And I think that's a step that Congress specifically chose not to take after September 11th. That Congress was given the option by the Bush administration of passing a blanket AUMF. And Marty, if I may, I think the difference between what Jen and I talked about in our response and what Bobby and Jack and Ben and Matt talked about in their papers, I think there's something to be said for AUMF 2.0, which is should there be an AQAP AUMF, right? Should there be an AQI? But what we take, along with Bill the Kearney, but what we take the full discussion is AUMF N.0, which is to say, we are going to pass a framework statute that forever delegates to the president the power to decide which groups cross that threshold. I don't know why you can't have that public debate that we agree needs to happen when Congress passes an AUMF or AQAP. I mean, it seems to me that the question is not, should Congress pass a subsequent AUMF if ever there comes a point where a group poses that threat? The question is, should Congress do it retail or should Congress do it wholesale and delegate the power to the president? And I guess to my mind, that's where the real difference between our views is. That for us, we think, I think it's safe to say, we think there's no reason why Congress couldn't do it retail. And I think the gist of the paper is that that's not true.
Well, look, let me respond to that. I think the retail-wholesale distinction isn't hugely important. If what it comes down to is we all agree that something ought to be done along the lines we've described, and the question is only, should we name some specific groups now and then kind of be prepared and have Congress in the mindset of, you may have to come back and do this again and again, versus whether there should be this listing framework where Congress sets the intelligible standard and then the executive branch acts on it. I'm not going to lose a lot of sleep over that distinction. I think we've accomplished a huge amount if that's what we're all in agreement on. But let me say that I do think that there's something that turns on it. In the example I gave, so the executive branch would surely claim the Article 2 authority in that circumstance to use force as I've described here. And bearing in mind the imminent standard being converted from temporality to categorical imminence, as David Riley put it earlier, this authority's already been claimed for exactly this set of categories. We're trying to bring in the detention, so we can talk about whether detention is maybe something that's different here, but the authority's already there, but you and I don't know about it. It's not in public. And under our model, it would be.
Jim, last word on this.
Well, I just want to be clear. I don't think that we're completely in agreement about that last point. I don't think what we're saying, or clearly what I'm not saying, and I think Steve agrees with me on this, is that we're at a point where we need to, it may be the case that there's enough information out there which would have to be put forward by the administration, in which case there was a need to have a new AUMF activity, for example. If that were the case, we would need to have a public debate about it and a discussion, and then there would be a new AUMF limited to this specific group, along with a repeal of the current AUMF. But we are not at the point where we are suggesting that that is in fact needed at this point, because we think for a number of reasons, nor are we suggesting that it's needed for any groups beyond possibly AQOP, at least based on what's available in the public document.
So let me just ask one question of Jim about international human rights law, and then throw things open to the audience. And the question is this, and it jumps off this discussion. If the United States, one way or another, is going to insist on applying a humanitarian law model, whether it's recognizing the right to investigate or not, but it is applying the laws of war model in an atmosphere where that seems, at least on the ground, from what we know, less and less justifiable. And the rest of the world is going to insist on applying a human rights law model, which is to say also a criminal justice model. What's going to give? What are the implications of that with regard to the rule of law in each regime, and what is that going to mean with regard to U.S. exceptionalism versus the rest of the world in terms of how to confront terrorism?
Yeah, well, I think the U.S. exceptionalism element is really important. You know, the drone debate has focused on the United States. There are some 70 countries in the world that have drones. Most of these are surveillance drones. But you do have a half a dozen countries or so that either have or are likely to have armed drones. The example was raised about China going after maybe individuals in the United States such as Falun Gong. Maybe that's not such a realistic example, but Russia will undoubtedly have drones. May want to go after Chechens throughout Europe. And the United States is in a position right now to be setting the debate on what law is applicable. And if the notion is, no matter, even if the Obama administration denies that it's using a global war on terror paradigm, it effectively is. And that is sending a message around the world that that will be the accepted paradigm for the use of these weapons. And the United States, I feel, has a real responsibility at this point to accept that, well, in much of the world, including in places where drone strikes are now being taking place, that, in fact, it is a law enforcement paradigm. The law enforcement paradigm really requires much greater limits on the use of force. We've heard the term imminence thrown about a bit. Imminence is used in two important contexts in international law. One in terms of self-defense under the UN Charter, an imminent threat is talked about, and at the same time, the notion of imminence is used in a human rights context for when police can use force, when there's an imminent threat to life, such as, say, a hostage taker who has a gun and holds it to the head of a hostage. The police, in such a circumstance, could shoot and kill that hostage taker. But the administration in its various speeches has used this term sort of vaguely in both contexts, which is actually confusing the issue rather than bringing more clarity to an important issue.
I think that last point is very important, and also I think highlights another distinction possibly between Bobby and where Steve and I are standing on this issue, in that Bobby made the statements that the administration, we've already passed the Rubicon where we've reinterpreted imminence. And I'm not sure we're there. I think that it's a debate we need to have. The administration has offered a very broad definition of imminence, but in the context of imposing policy constraints on who it can target in the context of an ongoing armed conflict. And it has not yet, in my view, ever publicly stated that this broad definition of imminence also applies to separate standalone self-defense authorities. I think that's an important distinction.
I'll go to the audience. First, Mark.
Thanks, Mark. So, to go to the Kevin Costner question, thanks very much. To what extent is this AUMF 2.0 really backing a solution into a problem that isn't stated yet, but maybe is GWAT 2.0? It turned out that the first global war on terror was actually a war against Al-Qaeda. Do you now see that there's a need for a second global war on terror, which we start to take seriously, a global war on terror, and that's why we need AUMF 2.0?
If I'm following you correctly, you're asking if, in effect, we should have, after all, just declared war on all terrorist organizations capable of threatening the United States and enact on that. I don't think that's what I'm saying. What I'm saying is that the actual status quo we currently live in and have been living in for years is, yeah, it's a war with Al-Qaeda, but it's also a war with groups affiliating, spun out from, or joined up to in various vague ways, Al-Qaeda, and groups that aren't, right? Especially in the Flaherty region, all sorts of groups that are not Al-Qaeda linked, not Al-Qaeda affiliates, but we're using force against. There's a whole array of them. We can't list them. It's not known to the public. We've been talking about how the idea that the test is co-belligerency. Beyond that level of detail, we don't really know what the standard is, nor how it's been cashed out in particular cases. What I'm suggesting is this model should be transformed into something transparent to the public so that these sorts of decisions take place in a way that you and I know that they've taken place. Not that we therefore should actually use such an authority and immediately act on that against any and all possible groups. And there's all sorts of policy reasons, an endless array of strategic and operational tactical reasons why you might not act on any circumstances where you otherwise could. And the same, by the way, is already true under Article 2. The type of standard I'm talking about, which I described earlier, was, I think, almost indistinguishable from what the executive branch lawyers would say, but there was an attack on American citizens and this group is capable and willing to do it again. You don't actually need the statute. It's good to have the statute. You want the statute. You don't actually have to have it. So these sorts of decisions are taking place. I'm trying to move them into the light rather than the shadows.
The gentleman in the yellow top, I saw it, and go on.
Yes, I have a question for Mr. Vladeck, but I just want to comment with regard to the idea of a prospective court as opposed to the post facto court. In addition to what Mr. Ross said, there's another strong policy reason, forget about Article 3, for not doing it. I've spent 40 years trying to get federal judges to understand and use the constitutional power they have in areas where they're afraid to do something regarding national security and secrecy. I worked on both the original FISA law and the modification. With rare exceptions, it is basically a rubber stamp. And what will happen if you create a prospective court, although I agree that the more checks in theory, the better, is that the Article 3 judges will then back off exercising the power under what Mr. Vladeck proposes, because they'll say, well, let's leave it to the people on the inside. But my question for Mr. Vladeck is that what cuts across all of the issues, both panels, is the problem of secrecy, vis-a-vis accountability. The first threshold problem is getting the Obama administration to support the state secrets law, which is pending. They've said they don't oppose it, but they can't support it, which of course is death. My question is, in addition to the state secrets problem, you have the question of standing, and you have the question of forgetting the name of it, when they say we can't deny or we can't affirm. Louis Glomar. How would you deal with those? The Court of Appeals in D.C. recently reversed, but it was a very unique decision because every government official had admitted that we have drones. How would you deal with those in regard to your cause of action, which I like very much?
No, those are great questions. Thank you for them. All I'll say briefly is I think the standing question, my idea would be to model any such cause of action on a wrongful death cause of action. And so, I mean, this is, one of the moral tragedies of my proposal is I don't mean to make light of the fact that in cases that I'm proposing, the person who was actually allegedly injured is dead. Right? And I don't mean to make light of that, but, we already have legal mechanisms that deal with that, which is to say, the idea of wrongful death suit, where it's the decedent, it's the heirs, it's the estate of the person who was killed who can sue on his behalf. I don't think there's a big standard problem.
The problem, too, is not that. It's how do they know? In most cases.
Well, ironically, I mean, I actually think ironically, here's a case where there's less of a knowledge gap than in the FISA context. So in the FISA context, the problem is that if you are the target of FISA surveillance, it's almost never going to be the case that you find out. Right? I think in the context of a drone strike, if you're the target of a drone strike, I dare say you usually find out. And I don't mean to be coy about that. I mean, I think there is going to be physical evidence that will get you over the threshold in that context. The Glomar point is an interesting one. I mean, I think the short version is that Congress can provide by statute for whatever secrecy procedure it wants. I mean, I think this is a myth that pervades the national security litigation you're alluding to, is that it's the Constitution that protects the secrecy of national security procedures. It's not the statutes, and it's executive orders. Right? I mean, Congress has since 1954 taken at least some role in regulating classified information. And I think Congress could, as it did in Section 1534 in the Alien Terrorist Removal Statute, provide for a very detailed regime that the courts would never quarrel with, especially if it was a regime that did try to protect the government interests the way that 1534 does.
I'll just say real quick that although I'm sympathetic, I think it's not nearly so clear that there's no constitutional element here. I'll also draw attention though to one other model that you didn't mention. The Invention Secrecy Act of 1950, I believe, is a completely random statute that actually does very much what you're talking about as well.
Well, and just on the constitutional point, all I want to say on the constitutional point is just that I think there might be a constitutional issue if Congress was willy-nilly requiring the disclosure of classified information. I think if Congress is simply providing alternate procedures pursuant to which such information can be shown ex parte and in camera to a judge and to security cleared counsel, I couldn't imagine what the constitutional challenges of that would be.
Good morning. And we're going to go to about 1:10, so I'll give you one more question after this.
I want to try to bring you all back to the link between detention and targeting in connection with the AUMF. And that, I guess just ask for your reaction to the proposition that this is kind of an accidental debate that you all are having. And the accident is that in the aftermath of September 11th, the Bush administration, because of its reactivism and combined with a lack of sophistication about international law, decided that they needed to determine that everyone they wanted to detain had to be called an unlawful enemy combatant. And ever since then, we seem to have been in a framework that has not changed of an assumption of an armed conflict framework by virtue of that original concept, that original declaration. Do you think that if it hadn't been for the fact that they overbroadly determined what they needed to do by way of nomenclature for detention, that we might not be having to have this debate today?
Is the idea that security internment was a path they didn't take? Is that what you're getting at? Combatant security internee, GC4 kind of distinction?
It wasn't not necessarily GC4, but even the concept that in non-international armed conflict as well, you could conceivably detain people who aren't necessarily combatants as long as you had a proper legal framework to do so.
I don't know if I entirely agree with the proposition, but I think your point is an interesting one, and it gives me pause to think that could be right, that certainly there was when you contrast the framework we used in later years in Iraq, where we very quickly moved into a security internment GC4 modeled framework and got away from everybody's a combatant at all times. It shows you it can be done. In the right circumstances, we will do it, but we've never retrofitted that model to Afghanistan. We've never retrofitted it to Guantanamo or elsewhere. So maybe there is kind of a path dependency, like you said.
I also think that to the extent that what is motivating some of this discussion is the sense that there's this need for administrative detention. To some extent, it doesn't matter whether you're talking about a GC3 framework or a GC4 framework. The point is that there's this desire or this sense that new forms of administration detention may be somehow necessary in the future, in my opinion, without any real justification for the claim.
I think we have time for one more question. I caught the gentleman in the blue shirt there. While the microphone was making its way up, I also wanted to thank Steve for his part in organizing this as well, along with Susan and Karen. So.
Okay, my question has to do with the notion of unilateral action. Everything that was been talked about today is taken for granted that these actions are unilateral, and I'm just asking if there aren't any restraints that should be applied because of the U.S. unilateral decision-making that goes into it. Is there anything that should constrain our government in terms of either, the UN Charter or international considerations?
This is the use and development question.
I'm not sure what you mean by unilateral action, though. I think it's fair to say that efforts dealing with the real problem of terrorism are best addressed in cooperation with other countries. And when you have a policy or practices like the drone program that will deter countries, particularly in Europe and the like, to get involved and to provide their assistance. And I think countries have already made that clear to the United States. At the same time, there's also concerning matters that some countries that have drones have been unwilling to speak out publicly against issues that clearly are a concern internally, such as the UK. We see with France, who may now have more of an interest in using drones in a place like Mali, holding back. And one would like to see more concerns raised by governments that do have human rights concerns about the use of targeted killings and the like that haven't been outspoken enough. But I do think it does affect cooperation.
Well, I think the cooperation I think also goes to I think one of the places where Jen and I on one hand and Bob differ, which is to say, we've been incredibly successful in using international cooperation in conjunction with our criminal justice system to acquire, to interdict, to stop any number of terrorist attacks, terrorism suspects. We can look no further than the current pending case against Abu Ghraib, right? The Osama bin Laden son-in-law, and the not yet I think fully public, but I think we can all safely say clear evidence of international cooperation that helped land him in a federal court, downtown Manhattan. And the concern is that, there's a story in the Times a couple weeks ago about how it's actually getting harder in cases where there are questions about our policies abroad to always get cooperation from British intelligence, from British police, etc. And that's something we should be worried about. I mean, it's one thing to make a proposal on a sort of even slate, on a blank slate, for new methods. Another thing if it's actually going to affirmatively weaken our ability to use the processes that are already in place.
Well, with that, I'd like to thank the panelists. And let me turn things over to Karen for an important announcement about lunch.
Yes, and the important announcement is this. If you think it's complicated thinking about the war on terror or the global war on terror too, wait till you start thinking about cyber. And wait till you start thinking about how big the world actually is if it's outside of Al-Qaeda. So that's what I invite you back for after lunch. Lunch is served outside. Help yourselves. We'll see you back here in half an hour or whatever our schedule says.